Hello everyone, I wanted to welcome you to the Hampton Law Firm, and I wanted to hop on real quick and talk to you about how to get your marijuana charges dismissed in Texas. All right, I want to encourage you to subscribe to our YouTube channel for more great content just like this. Now today I want to explain to you the ins and outs of how to defend your marijuana charge in Texas, and more specifically what some of your options are and some things that you can do to help make sure that your case is dismissed and ultimately so that you can get that arrest off your record. All right, now listen, if you wait around to the end of this video, I'm going to give you a free resource, a free ebook, what to do if you have been charged with a crime in Texas. All right, let's jump right in. Now, marijuana possession in Texas. Now, if you're charged with marijuana in Texas, it's important to know what your options are to get your case dismissed and off your record. Now, the first thing we have to look at when we take a look at marijuana charges is we have to determine how much marijuana was seized by the police. Now, in Texas, in order to determine if your case is a misdemeanor marijuana charge or a felony marijuana charge, we have to look at the weight of the items, the weight of the drugs seized. So if the amount of the drugs that were seized were 4 ounces or less, then you're going to be looking at a misdemeanor charge. If it's over 4 ounces, then we're looking at a felony charge. Now, I'm going to just tell you right now, a felony case, a felony marijuana case, whether it's 4 ounces to 5 pounds, 5 to 50 pounds, it goes up based upon the level and the amount of drugs, the actual weight of the marijuana that you have. Those are very specific fact scenarios that we need to look at. When you're defending a felony marijuana charge, we need to look at the search. Did the police conduct the search correctly? Can the police affirmatively link you to the illegal substances? And if not, can they prove that you truly exercised care, custody, or control over the item? Now, what I mean by that is we've represented clients in the past where they've just been a passenger in the car and there was drugs under one of the seats in the car. The other person's driving the vehicle, they're just there with their friend, they get pulled over and they get arrested for possessing marijuana. Everybody in the car gets arrested. Well, the police can't just arrest everybody. They have to be able to show that you intentionally or knowingly exercised that care, custody, or control over the drugs in order to prove the case. My point is, all of those points need to be looked at. All of those issues need to be looked at and examined early in the case, because it's possible that the case may be able to be no-billed by a grand jury on felony marijuana charges. All right, so that's felonies. Now let's take a look at misdemeanor marijuana charges. We're going to spend our time looking at this for a second, especially if your case is out of the Dallas-Fort Worth area. If you have a good attorney, there are a couple of options that are available to you. We're going to look at 3 of them today that can help ensure that you're able to get this case dismissed and ultimately off your record. Now, I'm going to be frank with you. Some of these options are better than others. So let's jump into them. Let's take a look. Number 1, your case may be able to be dismissed for lack of evidence. So I talked about that a second ago on felony marijuana charges, but it may be that your case can be dismissed because they can't prove that you actually exercised care, custody, or control, maybe, over the drugs. They may not be able to establish and affirmatively link you to those drugs. The search may have been illegal. There's a number of issues that may be out there that would allow us, after we take a look at those police reports, to argue that the state of Texas will not be able to prove this case beyond a reasonable doubt. Remember, you don't have to prove anything. The government must prove the case beyond a reasonable doubt. So number 1, your case may be able to be dismissed for lack of evidence. Number 2, you may be able to also get what's called a conditional dismissal. Now, especially in Tarrant County, Texas, one of the options that they're doing right now is that the DA is saying they want to see sobriety. So it may be that if you can give 3 clean drug tests over a 90-day period, once every 30 days, that after you show clean drug tests for 90 days, it may be able to be negotiated for a conditional dismissal. Okay, that's point number 2, conditional dismissal. Number 3, the final one is a diversion program. You could potentially participate in a deferred prosecution program or a first offender drug program, and the case can also be dismissed under that scenario as well. Now, people ask me all the time when they call in to speak to me, which is the best option? If you're going to be seeking after a dismissal, is there one that's better than another? Well, I am going to tell you this. Let me give you an illustration. Sometimes it's better to go with the diversion program than it is the conditional dismissal. It depends on how quickly you need this arrest removed from your record. Here's my example. On a conditional dismissal, you have to wait at least 2 years. You have to wait 2 years from the date the case was dismissed. On a conditional dismissal, you have to wait 2 years before you're able to get it expunged from your record. 2 years. Now, here's the difference. On a diversion program, for instance, if you have a misdemeanor marijuana charge, the program is only 4 months long, and at the end of the 4 months, the case is immediately dismissed and you are immediately eligible to get it expunged from your record. So I represented a medical student who I had these two options available to them for a marijuana charge. And they told me, Jeff, I have to jump on this option where I can get it expunged from my record immediately. If I have to wait 2 years before I can get it off my record, my employer's going to see it. They're going to be aware of what's going on. It could cost me a job opportunity. And of course, this was somebody who's going to become a medical doctor. So they wanted to make sure and not have this out there on the record. So really it depends on your situation, but many times not all dismissals are created equal. All right. Now, if you need some help with your marijuana case and you have some questions for us, don't hesitate to call the Hampton Law Firm at 817-877-5200. I promised you if you waited around to the end of the video, I would give you a free resource, what to do if you've been charged with a crime in Texas. Click right here on the link right down here below, and we'll be happy to send that over to you through your email. All right. Thanks for joining us today, and I look forward to seeing you next time through the Hampton Law Firm. Have a good day.